Okay, till last session we completed the part up to return statement, counterclaim and set off. Now we have to move towards the next part in which we are going to learn the examination of parties or the another kind of parallel part. So these are the important things that we have to cover in today's scenario and till the execution of decree. So all this topic we have to cover side by side. So basically till the time we covered that once the summon received by opponent party or the defendant or the respondent or the सामने वाला or the प्रतिवादी, his duty to give the reply in the court of law by his own or by his advocate. So all this part we cover. Apart from the written statement, he have an option if he wanted to claim something as a new suit, but in the same suit he can give the application of counterclaim and it will be treated as a new suit only. And until the time plaintiff is not giving any reply or court is not going to decide the counterclaim, till time the original suit will be remain same at the same position. So if counterclaim will be done or the counterclaim will be filed by the opponent party or the defendant, it must be heard first, it should be decided, then and then only case will be continue or the resume from the point. Then after we gone through the important part that we can say set off. Set off is regarding the if any monetary purpose or the monetary claim will be there in that particular suit, then whoever the party, even plaintiff or the defendant, if any remaining amount will be there on the either person, then that amount will be deducted from the major claim, and the deducted amount on that particular basis the suit will be continued. So that part we cover in the last session. Now we have to continue from the point number C. If you can look after the same point of view, so it would be better. So one by one we have to cover all this topic till the third. Okay. Withdrawal of suit. Withdrawal of suit means whenever any party is going to file the suit, we are giving some right to the parties to withdraw the suit at any stage for the compromise purpose or for any other reason. So this kind of rights we given to the parties. So withdrawal of suit means whenever any party, means one plaintiff is going to file the suit in the court of law, then we are giving some right of withdrawal of suit, means to wipe out the suit, cancel the suit. We can say that we don't want to do anything in this particular suit, particular case, we just have to cancel the suit. So we are giving such a kind of application to the court, might be orally or many times in documented manner as an application. Then court will think on that, and in the withdrawal of suit, court can only suggest what you can do, what are the basic part are there, what are the pro or what are the cons, what are the advantage or disadvantage. But court can't restrict any person. The decision of withdrawal of suit, it's up to the party. Court is not going to interfere in that particular decision. But whenever withdrawal of suit is done, court is going to give the particular kind of instruction, in which court is going to give the instruction regarding once you withdraw the suit, you cannot file the new suit against the opponent party on the same point of view or the same point of issues. That kind of instruction are given by the court to the opponent party, to the party who is going to withdraw the suit, otherwise there is no any use regarding the same. ऐसे अगर नहीं करेंगे तो there is no any suit. Any person can file the suit, then withdraw the suit, then again file the new suit, then withdraw the suit. That will be totally harassing for the opponent party. That is why whenever withdrawal of suit will be there, court is going to give the instruction. It is duty of the court to give the instruction like that. Once you withdraw the suit, you cannot file the same suit against the opponent party on the same point of view or on the same issues. So that's really the part for the that we can say as withdrawal of suit. Withdrawal of suit is done at any stage of case, even on the first day, even on the middle of case, even before the judgment. All these parts are there regarding the withdrawal of suit. But at particular stage, if court can think it so, everything is done, only judgment is remaining, and now because of you're supposed to think the decision is not going to in your favor, and that is why you're withdrawing the suit. Then if court is recognize your mala fide intention, then court can take the strict action against you. Even the fine, it totally depending on the what are the discretionary power of the particular court, but court can take such a kind of action if any mala fide intention will be there. So this was the part regarding the withdrawal of suit. Withdrawal of suit is done by which party? Plenty for defendant. Harika ji, what do you think? Mahesh ji? Withdrawal of suit will be done by plenty for defendant. 5 plenty, 5 not defendant. अच्छा, तो वो डिफेंडेंट नहीं कर सकता है विड्रॉ.
सर अगर डिफेंडेंट ने कुछ लगाया है केस तो विड्रॉ कर सकते हैं.
अच्छा, मनोज जी, व्हाट यू थिंक? If case is filed by the plaintiff, whether it is withdraw by defendant or plaintiff, ऐश्वर्या जी, शशिधर जी, शिवराज जी, what you think? महेश जी, why it is so? और क्या हो गया ये? हाँ, गुंदेती, देवी प्रसाद जी, भवानी जी. ओके फाइनल. Okay. In this particular question, what we have to remember, whoever the party filed the suit is the only competent party to withdraw the suit. Why it is so? Otherwise क्या होगा? समझो मैंने किसी के खिलाफ केस रजिस्टर्ड किया है या फिर आई जस्ट फाइल द सूट और द इंस्टीट्यूट द सूट इन द कोर्ट ऑफ लॉ. सामने वाली पार्टी विड्रॉ कर देगी केस. कोई भी पर्सन समझो शिवराज जी ने कोई केस रजिस्टर्ड किया होगा, अपोनेंट पार्टी विल विड्रॉ द सूट, तो कुछ फ़ायदा है उस बात का? केस चलेगी ही नहीं आगे. whenever plaintiff is going to file the suit, opponent party will withdraw the suit. So there is no any use of regarding the same. It is totally useless. Otherwise, whatever the kind of application any party is going to file before the court, that particular application or regarding that particular application, the party who filed the particular application, that is the only competent party to withdraw that kind of application. But opponent party can supposed to give the opinion in the court of law or give the opinion to the court to dispose of the particular application on the some major ground or some whatever the random ground. Suppose you just file the suit, opponent party can suggest the court, sir, there is no any reason why this person is filing the suit. There is no any valid reason. There is no any valid background or the ground for the same. Why this party just filed the suit? This party is not having jurisdiction. This party is not having any monetary jurisdiction or the pecuniary jurisdiction or the any other alternative reason. There is no any evidence. On that point, opponent party can inform the court to dispose of the suit, but not for the withdrawal. They can only suggest, but they cannot withdraw the suit. So that will be the part, and the same things will be happen for the different kind of application given by both the parties. So whoever the party who filed the suit or the different kind of application is the only competent party to withdraw the suit or the particular application. So this will be the part. In the next part, we have to go on through the date of the parties. If any case registered before the court or heard before the court, and either party's date will be happened, also due to any disease or due to any accident or whatever the reason may be. If plaintiff is going to file the suit and due to some reason there was a cause of death of that particular plaintiff, then how the case will be proceed in the court of law. If there is no any legal representative on the behalf of that particular plaintiff, then the case will be disposed of, because whatever the kind of case will be there, whether it is civil in nature, not whether, but in civil in nature, whatever the type means, rent will be there, or the debt case will be there, or the any kind of family matter or the any other matter, in which maintainability of suit should be there, and the proper liability of any person. I think there is some issue in joining the meeting. एक मिनट दीजिएगा, लेट मी क्रॉस चेक कुछ इशू है क्या ज्वाइनिंग में. What are the issues are there? Screen is visible for everyone. स्क्रीन विजिबल है सबके लिए. अच्छा, लेट मी क्रॉस चेक दी सेम थिंग, क्योंकि ज्वाइनिंग करने में कोई इशू आ रहा है शायद. Okay. Now the next part is regarding death of parties. समझो किसी ने केस फाइल किया है, ड्यूरिंग दिस पेंडेंसी ऑफ केस आइदर पार्टी, प्लेंटिफ है, डिफेंडेंट है, विटनेसेस है, if any cause of death of either parties will be happen, then whoever the legal representative of that particular party, in which the person who filed the suit, he have a legal right to inform the court regarding that particular day, or the whoever the person who's belonging to that particular party, they have to inform the particular court regarding the death of particular party, whether it is defendant or the any witness or the plaintiff. Why it is important to give the information of death regarding any particular parties? Because of maintainability of suit. Suppose any party just file the suit and after some time he is no more and his advocate is just proceeding with the case, and maybe some of reason court is also giving some decision, but after that particular time court realize whoever the party who filed the suit is no more alive, then what is the use of to give the decision in this particular suit? And even if any person is not exist at all, then there is no any use to run the case and to waste time of the court, because in this civil suit, if any liability lies with any person, then and then only suit will be proceed in that particular matter, otherwise not. Suppose one person who is the officer who's given some kind of decision in particular scenario, he given some decision on his authoritative ways. Suppose he is the officer of particular government official, or is the official person or the authorized person of any of the company, and is because of his decision some of the disputes all happen. समझो एक पर्सन है, वो कुछ गवर्नमेंट अथॉरिटी में है, गवर्नमेंट ऑफिशियल से कंपनी का कोई ऑथोरिटेटिव पर्सन है, उसने कोई डिसीजन दिया था और उस वजह से कोई डिस्प्यूट हुआ है और वो केस इन द कोर्ट ऑफ लॉ है. सपोज टू आफ्टर सम टाइम दैट पर्सन उसकी कोई डेथ हो जाती है, तो केस इज नॉट मेंटेनेबल इन द कोर्ट ऑफ लॉ, क्योंकि वहाँ पे लाइबिलिटी जो है किसी पर्सन की वो शिफ्ट नहीं हो रही है, क्योंकि उसने जो भी डिसीजन दिया था इट वॉज ऑन हिज पर्सनल बेसिस बिकॉज ऑफ ही वॉज सीट ऑन दैट पर्टिकुलर अथॉरिटी. समझो कोई कलेक्टर है, उन्होंने कोई डिसीजन दिया था कि हाँ ये पर्टिकुलर टास्क है, ये कंप्लीट करना चाहिए, इसे स्टेक हो, और उस पर्टिकुलर टास्क में कोई ना कोई रिश्वत खाई होगी किसी ने, या फिर उस पर्टिकुलर टास्क में कोई ना कोई डिस्प्यूट हुआ है और वेरी सडन केस फाइल हो रहा है, आफ्टर सम टाइम उस कलेक्टर की डेथ हो रही है, तो वो जो केस है वो उसके लीगल रिप्रेजेंटेटिव का हम इन जनरल मीनिंग लेते हैं, उसके जो कुछ भी रिलेटिव्स हैं, क्लोज फ्रेंड हो सकते हैं या फिर जो भी रिलेटिव्स जो डायरेक्टली उससे लिंक कर रहे हो, और दे कैन बी बेनिफिशियल फॉर दैट पर्टिकुलर पॉइंट. उन्हें नुकसान भी हो सकता है उस डिसीजन का, या फिर उन्हें फ़ायदा भी हो सकता है उस केस का या फिर केस के डिसीजन का. तो इन दिस सिनेरियो अगर कोई पर्सन एक अथॉरिटी पर है और उसके डिसीजन से कुछ डिस्प्यूट हो रहा है और उसके डेथ के बाद वो जो डिस्प्यूट वाली केस चल रही है उसका डायरेक्ट बेनिफिट या फिर लायबिलिटी अगर शिफ्ट नहीं हो रही है किसी और पर्सन के सामने, उसके लीगल रिप्रेजेंटेटिव के सामने, जैसे कि वो कलेक्टर है, ही गिवन सम डिसीजन, तो वो डिसीजन उसके पर्सनल अथॉरिटी में था, उसके डिसीजन से उसके वाइफ का उसके बच्चों का कोई लेना देना नहीं है. समझो उसने कुछ डिसीजन दिया है, उसमें कुछ पैसे का फ्रॉड हुआ है, दैट डजेंट मीन कि वो जो भी केस चल रही होगी जिसके खिलाफ हमने समझो एडमिनिस्ट्रेटिव कोई इंक्वायरी चलाई होगी, तो उसके डेथ के बाद वो इंक्वायरी उसके बच्चों पर आएगी, उसके वाइफ पर आएगी, नहीं. If any liability will be shift, then and then only this will be happen, otherwise not. जैसे कि समझ के चलिए लाइबिलिटी का मतलब क्या होता है. एक मैंने केस रजिस्टर्ड किया होगा सामने वाली पार्टी के खिलाफ, तो इन दिस पर्टिकुलर सिनेरियो सामने वाले पार्टी की डेथ हो जाती है और मुझे क्या चाहिए था, मुझे सामने वाले पार्टी से एक कोई प्रॉपर्टी चाहिए थी जो उसके नाम पर है, कोई इमूवेबल प्रॉपर्टी. लेकिन वी नो दैट कि भाई आफ्टर द डेथ ऑफ दैट पर्टिकुलर पर्सन दैट पर्टिकुलर प्रॉपर्टी विल डायरेक्टली शिफ्ट और द ट्रांसफर टू द his relatives or his wife or whatever the daughter or the son of that particular person or the parents of that particular person, है ना, ये सारी सिचुएशन हो सकती है. क्यों हो रहा है ऐसा? क्योंकि दैट प्रॉपर्टी इज बिलोंगिंग टू दैट पर्टिकुलर पर्सन हु इज द डिफेंडेंट अगेंस्ट whom the case is filed by the plaintiff, and because of that particular property, immovable property is belonging to that particular defendant, and after his death as a inheritance power, or because of the legal heirs, that property will lies to the or belong to the his wife or his son or the daughter or the parents or the brother or whoever the close relation person. Why it is so? Because there is some heirship power will be there. But it is only in case of that liability will directly shift to the another person. But if any decision will be given by the particular authoritative power of that particular person, whether it is plaintiff or the defendant, if there is no any liability after the date of that particular person, there is no any maintainability of case, then and then only whatever the case is going on, the proceeding of the case, it will be disposed of by the court if there is no any liability will be visible in front of the court. So these are the things for the death of parties. If any parties will be died over there, if any liability will be exist in that particular case, then whoever the party who filed the suit, he have to give the application before the court to remove the name of that particular opponent party or the particular party who just died over there, or even there is no any liability and more than one parties are there, whether there is a suit in which more than one plaintiffs are there or more than one defendants are there, and any either single party is going to die over there, then plaintiff have to give the information to the particular court with the death certificate, with the detailing of the same. We have to give the application and court is going to decide the matter. And if any liability of legal heirs will be there, court is going to give the instruction to add or the intervene any person who's having some liability in that particular case on the behalf of the died person, then their name will be added as a parties, whether it is plaintiff or the defendant. Then again the suit will be proceed over there. If there is no any such a liability, even though we have to give the application to withdraw the name of any person or the delete the name or the remove the name of any parties, because after the death there is no any liability lies over there. So these are the things regarding the rights of parties. Next part is regarding the marriage of parties. Marriage of parties means any case is going on and during the pendency of case either party are married over there, and if any liability will be shifted as a, if any lady will be there in any particular case and during the pendency of case that lady is married to some guy, in this particular scenario जो भी हस्बैंड है उसके ऊपर लाइबिलिटी डायरेक्टली शिफ्ट नहीं होती है, बिकॉज दैट केस वॉज बिफोर हिज मैरिज. लेकिन हस्बैंड चाहे तो उसके लाइबिलिटी ले सकता है. जैसे कि एक वाइफ है, वो केस वो हार चुकी है या फिर उसमें कुछ पैसे वाइफ के ऊपर निकल रहे हैं, देन अगर चाहे हस्बैंड तो वो लाइबिलिटी ले सकता है कि हाँ भाई आपके ऊपर 10 लाख रुपए देने हैं आपको, तो मैं देता हूँ आपके बिहाफ में. ये लाइबिलिटी लेनी ही चाहिए, ज़रूरी नहीं है. इफ़ हस्बैंड इज़ वेल एंड गुड, उसके पास पैसे वो देना चाहते हैं तो इट वुड बी बेटर. अदरवाइज डायरेक्टली लाइबिलिटी ऐसे सिनेरियो में शिफ्ट नहीं होती है. अगर किसी भी वाइफ का केस चल रहा हो जो शादी से पहले का हो, तो इन सारे सिनेरियो में ये सारी सिचुएशन होती है. ठीक है, तो ऑल दिस पार्ट्स आर रिगार्डिंग द सेम जो हमें समझ कर लेना चाहिए. ये जो कुछ भी सिनेरियो है मैरिज वाला, वो प्लेंटिफ केस में इतना दिखाई नहीं देता है हमें। प्लेंटिफ के सिनेरियो में या फिर जो भी हस्बैंड है उसके सिनेरियो में इतना दिखाई नहीं देता है, क्योंकि एज अ अर्निंग पर्सन ज़्यादातर लाइबिलिटी शिफ्ट नहीं हो सकती है किसी भी पर्सन के ऊपर या फिर हिज रिलेटिव जो भी वाइफ है उसके ऊपर। तो मेनी टाइम्स जो फैमिली वाला मैटर होता है या फिर जो भी वाइफ वाला मैटर होता है, उसी सिचुएशन में जो लेडी है उसकी शादी के बाद अगर कोई केस चल रहा है, उसी सिनेरियो में ये सारी सिचुएशन हो सकती है, अदरवाइज ये सिनेरियो एग्जिस्ट नहीं करता है उतना। तो एक छोटा सा पार्ट है मैरिज वाला। बाज़ दफ़ा लाइबिलिटी अगर शो ऑफ हो रही है इन दी कोर्ट ऑफ लॉ, देन हस्बैंड के सिनेरियो में भी हम किसी को ऐड कर सकते हैं। अगर इनहेरेंट राइट दिख रहा होगा या फिर उसके लीगल हेयर के सामने डायरेक्टली लाइबिलिटी शिफ्ट हो रही होगी, तो ऑल दिस पार्ट। इससे आगे वाला पार्ट होता है इंसॉल्वेंसी। इंसॉल्वेंसी का मतलब होता है कि भाई whoever the person against whom the case is filed or the by whom the case is filed means plaintiff or the defendant. Insolvency means he's not having in that much of position in economical or the financial position to give the allowance or the whatever the debt or the loan or the recovery or the rent in that particular suit or whatever the claim is there. He cannot fulfill the particular amount in the court of law because he is insolvent. Why he is insolvent? Because of so many losses are there in his company, or his job is not exist now because due to some reason. Then whoever the party who is insolvent, either he is plaintiff or the defendant, he have to file the insolvency application in the particular court, and court is going to give the authority to any commission, or they are going to establish new commission, and that commission is going to inquire regarding the insolvency by cross-checking the documents filed by particular person or visiting the place of the properties of that particular person, whether it is home or whether whatever the kind of properties are there which are supposed to be given in the insolvency application, they are going to cross-check, and that particular commission is going to give the report or supposed to give the report within stipulated time, and once the report will be filed before the court, court is going to cross-check that whether court is thinks that that party is really insolvent, then the whatever the pendency of the case or the proceeding of the case might be, court is going to stop that particular proceeding, because whoever the persons against whom you are going to claim some of the amount, if he is insolvent, then what is the use of to proceed with the case? But court can give such a kind of decision if you just claim 1 crore rupees against that particular insolvent person, then court can say that yes, we know you don't have that much of sufficient amount in your bank account, but not 1 crore rupees, but you can give some minimum amount on monthly basis or the weekly basis, likewise 10,000 rupees on weekly basis or the monthly basis or the 1 lakh rupees monthly basis, whoever the court thinks to fit, that particular amount should be filed by the insolvent person. Likewise, such a kind of decision will be given by the particular courts. Otherwise, there is no any such a kind of liability if any person is insolvent. Many times this kind of situations happen. Many of eminent businessmen are there. Whenever any dispute is arose in that particular companies, they simply file the insolvency application before the court, and they just raise their hand and inform the court, we don't have that much of sufficient money to pay in this particular claim. We don't have any kind of companies also to pay the amount again, and that is why we are just filing the insolvency application. Whatever the decision courts want supposed to do, court can do. And in the civil suit, you can just only give the civil custody. there is no any such a harsh type of any imprisonment or the death penalty or the life imprisonment. Not such a kind of activities are there in the civil suit until the mala fide intention is not there. So such a kind of insolvency application are filed by many eminent businessmen just to not to pay the amount, and that is why many times they are just running the companies on any ground. So these are the situation are happen in the many existing scenario in which either party having a right to file the insolvency application, and many times they are taking the advantages of the loopholes. So these are the things regarding the insolvency application. Amendments means in your application, in your plaint or in your written statement, you have to inform the court whenever any new cases or the new facts or the discovery will be there in this particular suit. As a plaintiff or as a defendant, court can allow us to rectify that particular point. And why it is important? Many times many facts are hidden at the time of filing the suit, and after some time we realize that new points are arose over there because of the new information, and the remaining information was false because of the new information we received. Many times new evidences are arose over there क्योंकि हम उसको लेकर अवेयर नहीं थे पहले. तो these are the things that happen. So that is why in simply manner in the suit filing or at the time of filing the written statement, we are giving such a kind of clause in particular plaint or the written statement regarding to give the information to the court whenever any new information will be asked over there. Court should allow us for the amendment in this particular point, but you cannot ask for the total change in particular suit. And this kind of decision will be taken by the court only. If court thinks fit to there is no any need of any amendment in this particular suit, whether it is in plaint or whether it is in written statement, then there is no any amendment in particular suit. So these are the things for the particular application. So these are the things that happen over here. Many times court is allow any persons for the amendment or for the rectification of that particular plaint or the written statement by enforcing such a kind of fines over there. So many things are there. After that, documentation means whatever the kind of evidences you are going to submit before the court, whether it is movable, immovable, whether it is digital, perpetual, imaginary, whatever the kind of evidences, that we can say it as a documentation. And with our application, whether it is plain or the written statement, on whatever the kind of evidences we are supposed to trust, and that is why we are claiming something before the court, that documents or that evidences we have to attach with our particular application, and it will be easy for us to inform the court these are the particular document or evidences we have in, and that is why we are claiming something. So these are the things. So documents parts we are going to cover afterwards also. So till the time documents means whatever the kind of evidences or the particular documents or the any particular of existing evidences, whether it is movable, immovable, perpetual, imaginary, that we have to inform the court as an evidence at a time of whatever the filing of suit or at the time of filing of written statement. Next part is regarding the witnesses. Witnesses means we know that whoever the persons who's witness for the particular fact in this particular suit, and they are going to give the evidentiary fact, might be orally or as a primary evidence or for the secondary evidence or the hearsay evidences. They are just informing the court regarding the fact of that particular suit or the particular issues of that suit before the court. That person, we can say it as a witness, and it is either from the plaintiff side or the defendant side. We have to give the list of witnesses before the court in advance, but not at the time of filing of suit. After the settlement of issue, we have to give such a kind of witnesses list before the court. So this will be the part we are also going to cover this point afterwards. Next part is regarding the amicable settlement. Amicable settlement means if both the parties who file the suit and the parties against whom the suit is filed, means plaintiff and defendant, if both the parties are think fit so, they don't want to proceed with this particular matter, they just want to do the compromise in this particular suit, then we just have to inform the court we are going to do the compromise or the mutual understanding, and due to our mutual understanding we think fit so we have to do such a kind of settlement in this particular suit, and if court is going to allow for the same, then you can do the amicable settlement and your suit will be disposed of. And at the time of disposal of the suit, you have to inform the proper reason why you are doing such a kind of withdrawal of suit, or court is going to ask the question. Even if you are going to withdraw the suit, whoever the plaintiff is there, court is going to give him reason. After the withdrawal of suit, you are not supposed to file the new suit or the fresh suit against this particular person on the same ground. First, you both the parties do your amicable settlement and inform the court in written you done with the amicable settlement, and then we can dispose of the suit. Or if you wanted to withdraw the suit, these are the particular things. You cannot file the suit against this particular person in future. But if any beyond the limit, any facts are established over there, then we have to move the application before the court for the fresh suit. Then if court thinks fit so, for that particular reason, then court can allow, because court have that much of inherent power. Many times happen कि भाई आपने दोनों ने एमिकेबल सेटलमेंट के लिए एप्लीकेशन किया था कोर्ट में और आपका सेटलमेंट भी होने लगा है और सेटलमेंट हो भी गया है, एंड विड्रॉवल ऑफ सूट के लिए आपने एप्लीकेशन भी दिया है, एंड एज पर दी विड्रॉवल ऑफ सूट कोर्ट इन्फॉर्म यू ऑल दिस इंस्ट्रक्शन एंड द सूट इज विड्रॉ. But after some time, plaintiff or the defendant realized that whoever the opponent party, he just thugging, he given the wrong fact, और इन सारे सिचुएशन में फिर आपका नुकसान हो सकता है. That is why in this particular scenario, you have to inform the court why the suit, fresh suit should be filed over there, and how the opponent party just given the wrong facts, or if he did some wrong with this particular person. So this kind of things are happen, but it totally depending on the inherent power of particular court. The next part is regarding the stay application. Stay application means in the proceeding of the main case or in the proceeding of the major case, or we can say that any either application or the parallel application or the miscellaneous application is filed before the court during the pendency of major case or the main case, in which court is going to give his opinion till the pendency of this particular case. The position of any property or the position of any fact or the things or the evidence should be remain same till the pendency of the case, or the till the next decision is given by that particular court. That means one case is going on, you are supposed to file the suit for the property, and along with the same suit you are giving one injunction application to the court for the stay application. and you are informing the court till the pendency of time, court should give the order whatever the properties belong to this particular suit or the dispute should not be visited by the opponent party, should not be encroached by the opponent party, should not be destroyed by the opponent party, because this property or this evidence or this fact are important to this particular suit. Otherwise it totally affect on the final judgment or the final decision of this particular suit. That is why whatever the things, whatever the evidences or the property, whether it is movable, immovable, are involving in this particular suit, kindly inform or kindly instruct the opponent party during the pendency of this case. He is not allowed to visit that particular property, to engage in that particular property, to destroy that particular property. Means we are just asking the court to give such a kind of protection during the pendency of the case. Otherwise there is no any use if we are not giving such a kind of application, and we are just giving the application to receive such a kind of property to you from the opponent party side, and during this pendency of case that opponent party is going to destroy that particular property or encroach on that particular property and misuse that particular property, and by the misuse he just sell the property, then there is no any use of this such a kind of cases, because court proceeding is lengthy. We know that. One, suppose I am just file the suit on the first day of December, then even after the 2 or 3 months case will not be on the board. Even next year of December 1st, only 2 or 3 stages are done by the court, and that is why such a kind of stay application is important, to give the information to the court during the pendency of the case. Court should instruct the opponent party, do not encroach, do not destroy that particular evidences or the property which is directly involved in this particular suit. So these are the kind of things that happen over there, and such a kind of application, such a kind of injunction application, in general local language we can say it as a stay application or interlocutory application, or any order are there in which we can say that interlocutory orders are there. Means during the pendency of case any order are given by the court, we can say it as a interlocutory order. An injunction order means any kind of orders given for the stay application. So such a kind of application we can say it as a injunction orders. So these are the things. Next part is regarding the payment into court. Payment into court means whoever the person who's filed the suit or against whom the suit is filed, and suppose they have to pay such a kind of amount for the maintenance purpose, or to deposit the amount in the court of law, for what purpose? To give that such a kind of amount to the opponent party. Such a kind of procedure we can say it as a payment into court. Means suppose you are the plaintiff and you have some claim, opponent party should pay you the maintenance of 10,000 rupees and court allow for the same. Then what opponent party will do? Opponent party is not going to deposit that particular amount in your bank account. No. That opponent party supposed to deposit that particular amount in the treasury or in the account of that particular court, and after depositing that particular amount in that court, you have to submit the slip or the deposited slip to the court, and then after court can also recognize that you already deposited the amount, and court will instruct the party who claimed for the same, and that party can withdraw the particular amount from the court. So such a kind of procedure is happened. In any case, you are not supposed to directly pay the opponent party. You have to pay that such kind of amount in the account of particular court, and you have to give the deposited slip to the court before the court, and court is informing the parties to the claim, and likewise the procedure is done. This kind of procedure we can say it as a payment into court, and payment into court is done by the court's instruction if any claim is there for the maintenance or for the deposit of amount or for the rent or for the debt or for the loan or any such a kind of fine are imposed on you as a party. That payment you have to supposed to pay in the court of law or deposit in the account department of court. So this procedure we can say it as a payment into court. Suppose one of the example is there. Plaintiff just filed the suit against the defendant, and after some hearing court realized that plaintiff is guilty, and that is why court is just given the instruction before the final judgment plaintiff should deposit some kind of amount or the n number of amount in the court, so court can finalize the things or finalize the decision. Otherwise, if court is not going to do such a kind of act before the judgment, that party or the plaintiff is going to out of that particular jurisdiction of the court. He just escaped from the jurisdiction, he just escaped from the state or the country, from the city, and there is no any use because he already realized the decision will be there in opponent party's favor, and whatever the amount is there remain over here. It totally lies to the plaintiff, and that is why in such a scenario court is giving such a kind of instruction before the final judgment that party should pay amount in the court of law. Means after the judgment opponent party can take the receive that particular amount which is already deposited by the plaintiff in the court of law. So such a kind of things have happened, and that we can say it as a payment into court. So many general existence of scenarios are there. Many times court is going to inform the opponent party or the defendant or the respondent to pay the amount. So either party can pay the amount. It totally depending on the scenario. Next part is regarding the court receiver. Court receiver means court is going to appoint any third party person or the any competent person, whether it is court staff, whether it is officer of the court, whether it is senior advocate, whether it is retired judge or any advocate which is government advocate or the private advocate, any recognized person who's done fit so by the court. They are giving the some duties to any person who's going to take care of particular property or the evidences or the things which are belonging to this particular case. That person we can say it as a court receiver. Means court receiver is the person who is the competent person, who is the impartial person, in which plaintiff and defendant also having some trust or faith, and that person is going to take care of any property or the evidences during the pendency of the case for maintaining the evidences. Means any property which is belonging to that particular suit or the dispute. Suppose 1 BHK flat, one building or the bungalow is there which are involved in this particular suit, and because of this kind of suit, if either party is going the application for the stay application, and that is why either plaintiff or the defendant is not going to protect that particular property. In this particular scenario, that property is maintained by the court receiver, and the court receiver is the competent person who is authorized by the court, who is the impartial person, who is a third party person. Plaintiff and defendant are agreed for that particular person, and because that person is taking care of that particular property, we are going to allow some amount as a remuneration to that particular court receiver during the pendency of the court, and that person is going to take care of that particular property till the pendency of the court or the next instruction from the court. So these are the things we can say it as a court receiver. Next part is regarding the commission. Commission means at any stage of particular case, court is going to appoint either single person or more than one person, whether they are the officer of the court, whether they are advocate or the senior advocate or the retired judge or the senior judge or the whoever the party court thinks fit so. Court is going to give the authority to that particular person or the group of person to investigate within the particular issues or the fact and give or submit the report before the court. That particular group of people or the person, we can say it as a commission. Under commission is a group of people or the person who are competent and who have authority by the court to done such a kind of investigation and file the report before the court. Likewise, we take the example regarding the insolvency, in which whoever the person giving the insolvency application before the court, after the application, court is authorizing one of the or establish one of the commission, and court is giving the authority to that particular commission, and that particular commission on the behalf of court inquire or investigate regarding all the properties belonging to that particular person who filed the insolvency application, and after the inquiring for the same, they have to submit the report before the court, and on that particular report, court is going to decide the matter. And whatever the report submitted by the particular court, that's supposed to be recognized as a that investigation or the inquiry is done by the court itself, because even single person or the group of person in that particular commission, they should be treated as a court only, because they are authorized by the court for that particular purpose of inquiry or the investigation. So that is why these are the things. But if any beyond the limitation or the beyond the law report is submitted by the commission before the court, then any person can take the objection over there. Means that amount is only of 10 lakh rupees, but the commission is mentioned 1 crore rupees, then it is totally beyond the limit. Then you can inform the court whatever the amount raised by the commission, it is not fulfilled because the evidences are differ and that person is totally lies over there. So these are the things over there that we can say it as a commission. Next part is regarding the ex parte decree. Ex parte decree means if plaintiff or the defendant are available in the court of law, then court proceeding will be done smoothly. But if either person are not available in that particular suit, then there is not such a kind of regular proceeding will be done. Suppose any plaintiff just filed the suit and after some time he just vanish, he just escaped from the particular suit, then what is the use of to run the particular suit or to proceed with the matter? Then there is no any use. Then in this particular scenario, court is going to withdraw the suit or the dispose of the suit, because whoever the person who filed the suit, if he is not interested in this particular proceeding, then court is going to wait for 2 or 3 hearings. Then after court thinks fit so, or on the application of opponent party, court is going to dispose of the suit, because plaintiff is not available in the court of law, either plaintiff or by his advocate. Likewise, if opponent party is not there, you file the suit as a plaintiff and the opponent party attend the hearing for 2 or 3 days, then after some days he just vanish or they escape from the suit. He is not attending the court at all. Then even in such a kind of situation, in this particular scenario, what will be happen? In this particular scenario, if suit is regarding the particular evidences, then court is going to recognize the claim done by the plaintiff, and the claim done by the plaintiff are totally existing over there, and which is proven by the particular evidences, even though opponent party is not available in the court of law or during the proceeding, either the plaintiff, defendant, सामने वाला प्रतिवादी, or by his advocate, they are not available in the court of law, even though if evidences are existing over there and it is proving that whatever the claim done by the plaintiff are existing over there, then court is going to give the favor to the plaintiff and court will decide the matter in favor of plaintiff, even though opponent party is not available in the matter. So these are the things that happen over there. This kind of such a practice or the procedure, we can say it as a ex parte, means in the absence of either party, court is going to proceed with the matter and court decide in the matter if either party are not available. If both the parties are not available, then court is going to proceed with the matter without the parties. Court is just waiting for the 2 or 3 hearing or some days. And if court thinks it so, both the party are not interested in the proceeding, then court is just dispose of the case. Because of both the parties are not available, then what judges are going to do over there? So that is why this kind of situation we can say it as a ex parte degree. The next part is regarding the dismissal or the disposal of suit. That means whenever any party are going to file the suit on any reason or any claim, if court thinks it so there is no any valid reason, then court have a full right to dispose of the suit at the first hearing. If any improper jurisdiction, improper claim, improper drafting, improper parties, not signed, court fees is not done, there is no any court fees are paid, there is no any opponent party, there is no any advocate, there is no any plaintiff attending the court, any kind of such a reason, if court thinks it so is valid for the disposal of suit, then court can dispose of the suit even on the first hearing or the any time of any stage of during this particular case. So this kind of things we can say it as a disposal of the suit or the cancel the suit on valid ground. Okay, so these are the things regarding the disposal of suit. Next part is regarding the examination of parties. After the filing of suit by the plaintiff, court is supposed to examine the parties. What is your name? Why you filed the suit? What are the reasons? What are the evidences you have? What are the claims are there? Did you ask for the compromise? Did you send the legal notice? Do you have any valid ground or the right or the claim? Any kind of such a questions that's supposed to be asked by the court, which are valid to the suit. Such a kind of questions are asked by the court even on the first day or during the pendency of the case. This kind of such a situation we can say it as an examination of parties by the court. This kind of examination are done by the court many times for the compromise purpose, many times to get the proper reason why the party filed the suits over there. Many times defendant are attending the court proceeding. So court is going to ask such a kind of question to the plaintiff also or to the defendant also. And what is the use of such a kind of question? Court is gaining the knowledge. Why plaintiffs filed the suit? What is the opinion of defendant? What is the background of suit? What are the facts? What are the different points or the aspects in this particular suit? So even on the first day when both the parties are happier or during this pendency of the case at any stage, if courts want to ask the question which are suits to the case, then court can ask. So such a kind of situation we can say it as a examination of parties. And many times for the amicable settlement, it is done under order number 10 or the section 89 of the CPC. Court is going to give the options regarding the amicable settlement or the compromise in the case. Likewise, One first thing is regarding mediation, second is conciliation or the arbitration or the lok adalat. Such a kind of procedure are done for the amicable settlement or for the compromise purpose. In the conciliation, it is totally compulsory in the family matter in which court is or the government are going to appoint any government officials or the permanent government official as a conciliation officer, and whoever the person filed the suit, court is going to instruct them before proceeding with the matter. You should have to consult with the conciliation officer. Whatever the questions are asked by the conciliation officer, you have to answer over there. Likewise, the procedure will be done. You have to supposed to visit the particular conciliation officer on the existing date. Then some question will be asked by the conciliation officer to you. Then on the next date, opponent party is going to visit the conciliation officer. Some question will be asked by the conciliation officer. On the next particular date, both the parties, plaintiff and defendant, should visit the particular date on which conciliation officer are sitting over there, and that particular officer is going to consult plaintiff and defendant both and ask why you're supposed to file such a kind of suit or such a kind of divorce petition, blah blah. And if that conciliation officer think fit so, or both the parties are think fit so, you want to do the compromise, then conciliation officer are going to submit such a kind of conciliation report to the court. And if both the parties are ready for the compromise, then the major suit will be disposed of on the ground both the parties are ready for the compromise. And if both the parties or the either parties are not ready for the compromise, then conciliation officer are informing the court regarding both the parties are not ready for the compromise, then the proceeding will be going on. So such a kind of things are there in the amicable settlement or the conciliation purpose. Next part is regarding the mediation. Both the parties, plaintiff and the defendant, informing the court they are going to do the amicable settlement with the help of any third party who is impartial, and both the parties are allowing that particular third party as a mediation officer. And that mediation officer is not a government official, might be your elder or his known person or he is the eminent member of society, whoever the person. We are going to give the authority to that particular third party, that we can say it as a mediator, who is going to consult only within the matter. He is just going to suggest, but both the parties are supposed to do the amicable settlement or not. It's up to the parties. So this kind of also alternative dispute resolution procedure for the amicable settlement or for the compromise. Next part is regarding the lok adalat. Many of the small cases or the petty offences which are done in the regular proceeding, you just have to give the application of lok adalat whenever it will be there in your particular area, on the tehsil level, mandal or the sub-district or the taluka level, or on the district level. You have to give the application for the lok adalat, and in the lok adalat the fast and speedy proceeding will be done by the lok adalat, and the case will be decided on 1 or 2 days only. So such a kind of one of the things like lok adalat. Then after, in supposed to many times, if any agreement or the contract are existing over there, and the contract or the agreement are existing with the valid clause of arbitration, then if any dispute arise over there belongs to that particular contract, or the agreement, then such a kind of arbitration procedure is going on. And after the arbitration procedure, the matter will be decided without interference of any court. But if any beyond the limit or the beyond the power or the beyond the law things are happen, then without arbitration only, also you have to file the suit before the court. But if any ground of arbitration is existing over there as a clause and both the party are agreed for the same, then the arbitration procedure will be done. So such a kind of situations are there. We are not going that much of deep because all these parts are differ and it takes some more time. Next part is regarding the documentation for the evidences purpose. In the documentation purpose, if discovery point of view, if we have to learn the discovery in this particular civil suit, then we can say that if either parties want to ask or want to confirm such a kind of fact or the issues from the opponent parties, then that particular party is going to write down the questionnaire or the number of question in the written form, and they have to submit the question to the court, and court is going to finalize the questions, and such a kind of question with the due permission of the court are supposed to inform the opponent party. Suppose you are the plaintiff and you have to ask such a kind of question to the opponent party, means to the defendant, means then you are going to write it down 2 or the 3 or the 10 number of questions, and you have to give the application to the court. Court is going to check the number of questions whether it is valid or not. Then after court is decide for the same, and after the deciding by the court, if court is finalize the question, then that question will be supposed to surrender to the opponent party, and opponent party have to give the answer regarding that particular questions, and these particular questions for the confirmation of facts or the things you are written over there in the particular plaint or the particular your application or the reply. Suppose you are the plaintiff, you are asked some kind of claim against the opponent party, and opponent parties write it down. Yes, I am going to give you 10 crore rupees. Then in the discovery purpose, you are going to ask the question number 1. Are you sure you are going to mention in the paragraph number 2 of your written statement, you are supposed to give 10 lakh rupees, 10 crore rupees to me? Question mark. Why we are written it down? Because we have to give the confirmation from the opponent party whether opponent party is supposed to ready for the same or not. So for confirmation of any fact or the issues, such a kind of questionnaire are given by the either parties, and after decided by the court, that particular question are supposed to send to the opponent party, and opponent party are going to give the answer in the written form. And whenever you are going to ask such a kind of question, you are not supposed to ask the irrelevant question or the mentally harassed question or the question like we are not belonging to this particular suit, or you are asking the opponent party to reveal such a kind of strategies in this particular suit. Such a kind of question are not allowed. And even whatever the question you are going to ask, you are not going to impose the opponent party. He have to give the answer. Whether opponent parties think fit to answer the question, then he is going to answer. Otherwise, he is not duty. He is totally remain it blank. If you are supposed to ask the 10 question, opponent party think it so he just want to give the answer for the 4 question only, then it's just answer for the 4 question. Remaining 6 are remaining unblank. So such a kind of things are there. That's supposed to procedure. We can say it as a discovery, or we can say it as a questionnaire. Okay. Next part is regarding the inspection. In any suit, as a plaintiff or the defendant, you are supposed to surrender or the supposed to give many kind of application or the evidences or the facts in the documented form, or in the photography or the videography, or any existing kind of type. You are supposed to inform the court regarding particular kind of evidences. Then during the pendency of time, many times many evidences are there in custody of opponent parties. Suppose you are the plaintiff, you are giving such a kind of claim, I have this agreement, I have this agreement, I have that property, I have that property, and such a kind of claim you done by the plaintiff. Likewise, opponent parties also claim, I also need such a kind of property. I want 1 BHK, I want 3 BHK, I want car, I want bike, because of I have such a kind of document which is a valid ground for me. Then either party are going to inspect your document, and you have to supposed to give the application to the court for the inspection purpose, and after confirmation by the court, you're supposed to visit the office of that particular either opponent parties, and whatever the documents or the evidences you supposed to cross check, you're going to cross check all this in the presence of opponent party, and whether you want the xerox copy of that, you can ask for the xerox copy, but whatever the xerox copy are there, you supposed to pay the amount of that, whatever the amount will be there for the xerox copy. So likewise, if opponent party are going to claim for such a kind of things, he having some evidences over there, and that is why he is claiming something, so you can ask for the to cross check that particular document on which that opponent party is going to claim. He wants some 1 crore rupees or the 10 crore rupees. So by the inspection procedure, you can cross check that particular document, even you ask for the xerox copy of that particular document. So such a kind of procedure is happened in the documentation purpose. So that procedure we can say it as an inspection, in which you are going to finalize or the cross check the particular document or the evidences filed by the opponent parties. Okay, so these are the things. Next part is regarding the production of document. Production of document means whenever either party are going to produce any document or supposed to surrender or the give or the submit the documents means documents or the either kind of any evidences, whether it is in imaginary form or the whether it is in immovable properties document or the movable properties document. Documents means any kind of evidences, not only the documents or not only the paper or the pages. Means whenever you are going to supposed to submit the document for the witnessing purpose or for the evidence purpose before the court, that procedure of submitting the document, we can say it as a production of document. If after production of document, if court can think fit, so court can maintain the record of that, means whatever the document is submitted over there, court can maintain the record of that. Yes, this particular document is submitted before the court, produced before the court, we cross check the particular document, we read the particular document, xerox copy is also submitted for that particular document, an original we already seen, and that is why we are supposed to return the document. That returning procedure we can say it as a returning of documents. Means plaintiff or the defendant, they are supposed to show the particular document before the court, and after showing off, court is going to maintain the record. Yes, this original form of document shown by the plaintiff or the defendant, we already seen it, now we are returning it to the opponent party or the plaintiff. That procedure we can say it as a returning of document. Next part is regarding the impounding of document. Means if court think it so, or with the instruction of opponent party or the plaintiff, if opponent party or the plaintiff or the court think fit so, any document which is shown by the plaintiff or the defendant which as the evidences, it is important to this particular suit or the case, and in absence of that particular evidences, might be case is destroyed, might be it is harmful to that particular document or the evidences. If we are just supposed to return that particular document, either party or the opponent party is going to destroy or the vanish or the encroach on that particular property, or if that evidences is not existing over there, there is no any use of this case, because that is the important evidence for this particular suit. In this particular scenario, if court thinks fit so, or the either party informing the court such a kind of important document till the pendency of that particular procedure of the suit, or whatever the next decision of the court, till that particular time court is going to store that particular evidences in his own custody. Such a kind of procedure we can say it as a impounding of documents. Means any either evidences are there submitted by the plaintiff and opponent party is saying, Honorable Court, kindly do not return that particular evidences to the plaintiff. Otherwise, that particular defendant or the particular plaintiff is going to destroy that evidence, or he is going to sell that property, because that he is doing such a kind of acts, he is engaging in such a kind of acts, he is supposed to sell the property. That is why, Honorable Court, I am requesting you as a defendant or as an opponent, please do not return the particular document, otherwise that particular property is going to sold out, and once the property will be sold out, there is no any use of such a kind of case to be proceed, because that property is belonging to this case or the dispute, and if that property is not there, then what is the use of this kind of such a proceeding? So that is why many time plaintiff or the defendant or the court think fit so, they are just taking the custody of that particular evidences of the document in his own custody during the pendency of the case for the security of that particular suit. So they are just taking the custody, or till the next decision, or till the judgment. So all this such a kind of proceeding, we can say it as the impounding of document. Next part is regarding the security of cost. That means whatever the, if supposed to, just as we took the example of payment into court, suppose any person who filed the suit against the opponent party and after the some time before the judgment, court realized that that particular person is foreign, is having some foreign citizenship, is not having any immovable property in India, and that is why if we are going to give such a kind of judgment, if that judgment is against this particular person, he just escaped from the country, and that is why court is going to instruct the party, you just have to deposit such a kind of amount in the court of law as a security. So suppose if in future you are not available, so we can give that particular property or the amount to the opponent party or the whoever the party in which that decision is in favor. So this is a kind of situation that we can say it as a security of cost. Next part is regarding the affidavit. Security of cost is also in scenario in which any maintenance cases lies on, and so husband have to supposed to give some particular amount on monthly basis to the opponent party or to the wife. Then in this scenario, if court think fit so, husband is not going to give such a kind of amount on every month. So in this scenario, court is also asked the husband to deposit the lump sum amount in the court of law. So wife can just ask whenever wife needs the maintenance on monthly basis, we just withdraw the particular amount by the due permission of the court. So such a kind of things also lies in between security of cost. Next part is regarding the affidavit. During the pendency of the civil case, whatever the kind of written information you supposed to give the court, which should have some authority, that whatever the information which supposed to have to give in the affidavit form, that means whatever the written things or the written confession you are going to supposed to give before the court during the pendency of the case, which having some authority, because you are giving that particular information to the court on the written form or in the affidavit form, and that is why that information having some authority. Why it is so? Because whenever you are going to submit such a kind of affidavit on the stamp paper or by the notary before the court, you are going to write it down one of the paragraph for the verification clause above information, or the information mentioned above is true as per my knowledge, and if any false will be happen or the wrong will be happen to the above confession or the above information, court can take strict action or court can initiate criminal action against me, and I am ready for the same. So such a kind of affidavit we have to give during the pendency of the case, whenever I have to give such a kind of important information to the court. So such a kind of situations are there in which we can say it as a affidavit in which I have to submit some information to the court. Next information is regarding the miscellaneous application. Means during the pendency of the case we have to give different kind of application, many times for the execution application, many times for the adjournment application, many times for the death certificate, or any such a kind of application which are existing for any purpose, that we can say it as a miscellaneous application. So random applications are there during the pendency of case, starting from the first stage to the last stage we supposed to have to give to maintaining the case. So such a kind of things we can say it as a miscellaneous application. After all this documentation part are done before the court, even for the discovery or for the inspection or for the impounding of document, production of document, returning of documents, now so court is in position, court is also aware about the facts or the things of plaintiff, court is also aware about the facts or the things of the opponent party, court is also aware about what is the opinion of opponent party on the document of the plaintiff, even court is also aware about what is the opinion of plaintiff on the document of the opponent party, and that is why court is supposed to come to that particular position if both the parties are filed their own documents, file their some evidences, and both the parties having some opinion on the either party's documents, and that is why now court is going to give his own opinion on the fact or the issues or the evidences of either parties. If plaintiff are going to claim for the 10 points and he having some evidences, defendant are going to claim for the 5 points and he having some evidences, and both the parties are having some opinion on the opponent parties, and now court is supposed to do, court is also having the evidences of plaintiff, court is also having the evidences of defendant and both the opinion of either parties, and likewise court is going to cross check both the evidences or the facts or the opinion, and now court is supposed to comes to the point that whether 10 points from the plaintiff sides are valid or not, whether 5 points from the defendant side are valid or not, then court is going to cross check on the basis of validity by the particular evidences, and court is now going to finalize number of points on which supposed to the claim or the case should be maintainable afterwards. Because before this particular stage, plaintiff claims something blah blah 10 or 10 points or the 20 points, but there is no any such evidences court found. Defendant also claimed 5 or 10 points, but there is no such evidences points are there, and that is why in this particular point of view our court are supposed to finalize the facts or the issues made by the either parties, and this procedure or this stage we can say it as a settlement of issue. That means court is aware about both the parties' fact and what are the evidence, and whatever the claims are there, what are the supporting evidences are there or the opinions are there, and on that particular point of view, court is going to finalize the issues or the disputed things or the facts, and likewise on the next stage court is going to finalize the settlement of issues. Means 10 claims are done by the plaintiff or the 5 claims done by the opponent party, but after court is going to cross check, court realize that only 2 points are there from the plaintiff side, only 1 point are there from the defendant side on the basis of evidences, and that is why now in the settlement of issue court is finalize the case, and court is going to give the decision that this suit will be proceed only on the 2 points of plaintiff now and only on the 1 points of defendant now, because evidence are there, opinions are there, and that is why only on the 3 grounds the case will be proceed afterwards. And such a kind of stage we can say it as a settlement of issue. And if court think fit so, there is no any such a fact or the issue which are supported by any document or the opinion which are maintainable in the suit, then court is simply going to dispose of the suit, because there is no any existence of the issues or the facts or the valid grounds. So such a kind of things are there. After the settlement of issue, both the parties will get the opportunity to submit their list of witnesses before the court. But in this examination of witness, whoever the party who filed the suit, he'll get the first opportunity to give the list of witnesses over there in advance, along with the affidavit or the confession which they are aware about the facts or the issues of this particular suit, and likewise the proceedings will be done. And after the completion of examination of witness from the plaintiff side, the examination of witness of opponent party are going to done, if they are supposed to give the witnesses over there in advance. It's totally depending on the scenario to scenario. There is no any compulsion on the examination of witness. If parties wants to do the examination of witness, they can do, otherwise not. So such a kind of things are there. In this particular scenario of examination of witness, we just have to inform. Examination in chief is there, cross examination is there, re-examination is there. Such a kind of things are there. We are not going that much of deep. We just have to remember the names. They are existing in the examination of suit. First, the examination of witness from the plaintiff side will be done. Then after, opponent parties witnesses examination will be done. So such a kind of procedure are done. Now, after the examination of witness, court is supposed to are in position. Court is aware about the evidences of plaintiff, aware about the evidences of defendant, or the opinion of both the parties on each other. Even on court is also aware about the witnesses of both the parties, and that is why court is going to give the last opportunity to both the parties to representing their case in the court of law through the argument on the particular suit. And now both the parties are going to argue in the matter by the written argument or by the oral argument. So many theoretical concepts are there in the argument point of view. We have to submit such a kind of evidences or the reference or the personification or the any books reference or the any precedents or the judgments of High Court or the Supreme Court, or any reference from the newspaper, whatever the scenario we supposed to do. We have to argue in the court. First opportunity will given to the plaintiff's advocate, then the second opportunity will give to the opponent advocate, and likewise argument will be done on the written view or for the oral view. So such a kind of argument will be done. After the argument, court is supposed to give the judgment. Judgment means after hearing all the matter in detailed manner, court is going to write it down, the decision in detailed manner, for what purpose they are giving such a kind of decision, because of this evidence we are giving such a kind of decision, blah blah, whatever the things in detailed manner. That's such a kind of point or the stage we can say it as a judgment. That can be given the information regarding the rights of the person, or how the rights will be done, how he should have to maintain his right. Many things are there in detailed manner. Such a kind of things we can say it as a judgment. Next part is regarding the decree. Decree means after the judgment, because we know that judgment is totally in the detailed manner, but decree means whatever the judgment is there, decree is giving the information regarding what are the existing right of particular person. That's it for the 1 or 2 page or the 3 page. Means if judgment it is of 10 or 100 of pages, the decree is a document which is supposed to give the information of rights of existing parties, or the plaintiff or the defendant or the whatever the favor. So such a kind of document we can say it as a decree, which is only giving the valid information of rights of different parties. That's it. And instead of judgment, whenever we required to give such a kind of right or the information of that particular judgment in future, we are attaching the decree, because it is the core point of that particular judgment. Because particular judgment it is in detailed manner, but decree is only saying as plaintiff having such a kind of right in this particular property. But decree is not saying because of this document, because of these evidences. No, it is saying it was the fact of judgment. Judgment it is in detailed manner, but decree is saying yes, plaintiff number 1 is having a right on this particular 1 BHK flat of Mumbai, address so and so. That's it. So decree is in precise manner, which is giving the information of rights of either parties. 2 types of decrees are there. One, it is for the temporary purpose, in which during this pendency of the case, if court is going to recognize the right of either parties, then that kind of decree we can say it as a temporary decree. Or after the judgment, if court is going to finalize the judgment, and after that judgment court is going to finalize the rights of any person, then we can say it as a final decree or the permanent decree. Okay, so such a kind of things are there. If any judgment is done by the court, and if that judgment that court is supposed to think fit, so some kind of decisions are there, we are not think fit, so it is belonging to us, or any disputed matters are there, then that case should be referred to the opponent or the hierarchy wise, whoever the higher court. Or in the same manner, one point will be there for the review purpose. If any judgment or the decree or the order are passed by the court, if that will be cross-checked by that particular court, we can say it as a review by the court. Along with the judgment decree, one part should be there, that we can say it as a order. Order means any kind of decision given from the starting of the case to till the last date or the judgment of the case, for smoothing the procedure, to maintaining the procedure, to speed up the procedure of that particular court or the suit. That particular thing we can say it as an order. That means if you are supposed to file the suit and after some time you are not attending the court, then court is going to give the order for maintaining the suit, to speed up the suit, to regulate the suit. And what decision court will be done? Court is going to give the order like till the 30th day of this particular month. If plaintiff is not going to appear before the court, then court is going to decide the matter and court is going to dispose of the matter. Such a kind of order is given by the court. So order means to maintain the case, to regulate the case, to speed up the case, starting from the case to the till last date of the case, court is supposed to give by his own or by the application of either parties, such a kind of decision, that we can say it as a order. So these are the things. If any judgment is not supposed to in favor of plaintiff or in favor of defendant, then whoever the party who thinks it so they didn't get the justice, then they can go for the appeal in the higher court, so that we can say it as a appeal. And the execution means when any decision is done by the court in plaintiff favors or the defendant favors, that particular parties are giving the application to the court for the execution, for the implementation of that particular order or the decree or the judgment. We are supposed to give the application before the court, and by such application court is going to give the authority to particular commission or the authoritative post officer to implement such a kind of decree or the order or the judgment. That such a kind of application we can say it as a execution of decree or the judgment or the order. Okay, so these are the important point we should have to recognize as the important stages in the civil suit, from the before institution of suit till the after the judgment or the decree. You can take the screenshot of these particular things, so it would be better. You can go through the same one by one whenever you will take the time or you need the time. Okay, I'm just zoom it out. Okay, so you can take the screenshot if you want, and if you have any question you can ask me now. In tomorrow's scenario we are going to continue for the criminal part, and that much of speed we can take, because during this 6 or 7 days we can't do that much of deep to instruct you each and everything, right? So many things are not covered by us in deeply manner, but this is the outline for the civil stages. If you wanted to think fit to learn all these things in deeply manner, so you can go with the our paid courses for the courtpractice.com, so you can go for the same. Otherwise these are the outline procedure, you can go for the same. So that's much we can say to you. Okay, if you have any question you can ask me now. Otherwise in tomorrow's scenario we are going to start with the criminal part, and we have to finish the criminal part. Okay, anyone have any query or the question, you can ask me now. जी, anyone have any question? Okay, look, what I am saying to you might be all the session are bored to you, because this is the theoretical part. Okay, if we have to finish it in 2 or 3 days, then it will be supposed to be done in such a manner only. So might be you think it, so you got bored over there, but this is the procedure. In the procedure of law we can't do anything. I'm not making such a kind of jokes during this theoretical part, right? So you are supposed to bear all this part. Okay, if you don't have any kind of question, then we'll supposed to continue tomorrow for the criminal part. Yes, Rajaswami ji, what kind of question you have?
Sir, in a civil suit, we have applied in a state level high court or district level court, sir. In that court, opponent party has been, and then after for the sake of justice, we have approached to high court.
Right.
And in that court, we are in the process. In middle of the process, that means the death of witness person has happened, and applicant person has got means plaintiff got death. The first hearing of the person are going to do the same suit, and they are ready to fight for this case. So what are the steps, and the next steps what they are doing opponent point party. If we win in the this court, they are again sending making a file in the higher court. So
Now,
they are wasting the time of the court as well as they are increasing the time of the delay in the
okay. Can you please loud more? What is the stage? In which court case is now? It is in high court or district level court? Sir, can you please loud more? Mic pass कीजिएगा. हाँ. Right now it is in high court. And what is the steps are there now?
right now it is in documentation and it is ready to verify the documents stage.
Okay, if appeal lies over there, okay, if appeal is lies over there in the high court, court is not going to go in that much of deep in the procedure of law. But if any objection on the evidences are there, which supposed to available as a claim in that particular appeal, then and then only court is going to cross check all this point, because high court is not having that much of power, because high court is only going to cross check whether the judgment given by the lower court it is valid or not, and what are the valid grounds are there, and on what ground court given the such a kind of judgment. So court is going to cross check all this part. Once the court is going to cross check all this validity of document, then court is supposed to give you the chance for the argument, and after the argument procedure, court is finalize the date for the judgment. That's the simple procedure is done in the high court. There is no any detailed procedure of law is done in the appeal stage. All this detailing of stage which we are supposed to understood, starting from the filing of suit to the detailing of reply by the opponent party, detailing of different kind of application, many things are there. Then after the documentation in the detailing for the inspection, discovery, admissions and denial, many parts are there. All these parts are done in detail in lower court only, but in the high court level you are supposed to give the application. Court is supposed to summon the opponent party is going to reply, and whatever the documents are there submitted by you as a appeal, that documents are going to cross check by the court, and if any objection done by the opponent party, court is going to cross check the objection, or whether the court thinks fit so whatever the documents are there in that particular case, court is going to cross check the validity of particular documents or the claim, and court is finalize the decision as soon as the argument is done. So this kind of simple procedure is done in the high court. There is no any complexity of the case.
Sir, in what happened in the process of procedure, they had taken a document against the state. They submitted the stay at the revenue department, and they right now it is in stay is passed against the land.
I'm not supposed to give you all the answer now, because I have to read whatever the criteria or the crux of your case.
Okay.
Because whatever the answer I'm going to give you, might be it will be insufficient, because the facts of the case are not there in front of me. If the facts of the case will be there, then I can supposed to give you the answer, because this fact now you are revealing. So whatever the answer given by me, it is not done for the particular point of view. So it would be better, whatever the stages are there,
Yeah, I will be
are there, that the next part is that there are so many loopholes in the case. Means you are supposed to give the summon to the opponent party, but many times during this summon, opponent party is going to file the different kind of case against you on the different criteria. Why it is so? because he just want to waste the time, he want to harass to you, but there is no any valid ground. You're supposed to give the instruct the court to give the some decision in your favor, not to file the case by opponent party. So such a kind of things happen over there. But as a advocate, you supposed to keep in your mind there are so many loopholes. Opponent party can take the advantage of any kind of loopholes. There is no any such a things. You have to have face all this thing for the mental harassment or for the all the purpose. And that is why civil suits are there for the 10 or the 20 years or the 30 years, more than that also, because many things are there. If you're supposed to appeal over there in the high court, opponent party having a chance, he just giving such a kind of exemption application because he's not feeling well. Next time he's giving to proceed for the different kind of application. So it totally depending on all other loopholes. So what opponent party is going to do, it totally depending on them regarding the facts of the case. So in your particular suit, opponent party is only taking the advantage of loopholes. There is nothing as per the facts given to you. Okay. Anyone have any question? Okay. If you don't have any question, then see you in next session tomorrow for the criminal part. Tomorrow and day after tomorrow we are going to finish with the criminal part. So thank you for joining this session. Have a nice day.
Thank you, sir. Have a nice